And when we broke, I was about to invite Mr. Knight to conduct his redirect examination. Um, I find that most recross is not productive, so I'll invite all other parties to listen carefully to the scope, which I'll be enforcing strictly um, following Mr. Knight's redirect. So, Mr. Knight.
Thank you. Good morning, panel.
Good morning.
Let's see. I'm going to have questions for each of you or most of you individually, but let's start out with one that's kind of more for the panel, and just tell me if this applies to you. Have any of you, in connection with your employment with the department, have any of you ever held a so-called Q clearance?
Yes, I have.
And does is that also known as a top secret clearance in the colloquial term, or could you distinguish it?
Q clearance is what was used in DOE. I don't know what that translates to in DOD or any other
Okay.
agency.
And in your connection with your employment with the department, um, are you aware that the department has received and maintained government secrets, including those involving Sandia National Labs or Los Alamos National Labs, or other secrets or confidential information involving nuclear secrets and things like that?
Yes.
And so, in your experience, does the department routinely receive and keep the confidentiality of some of this highly sensitive information?
Yes, we do.
And Mr. Herman, are you aware of that the department uh, keeps and maintains the confidentiality of information from our nuclear weapons facilities and things like that, or nuclear storage sites?
Yes, the groundwater discharge permitting program has at minimum two discharge permits for sites where we have either national secrets or confidential information that cannot be disclosed to the public.
So, given that information, do you feel that the department would be capable of maintaining confidential information from a produced water demonstration project? Do you have the? Okay, that's a yes.
Yes.
Thank you. Let's see. Let's go to Ms. Fulham. Are you aware of any person who has claimed that they did not receive actual notice of this hearing through at least one of the many different methods that the department used to provide public notice?
No, I didn't receive any feedback that this was not received by anybody.
And just a couple more questions. The department has been clear in all communications with the public since 2019 that this would be a prohibitive rule when it comes to discharge of produced water. Is that correct?
That's correct.
And as I think you have said several times already, this is not a produced water rule. This is a water reuse rule, correct?
That is correct.
Given that, are the definitions that we are proposing in this rule, are they only relevant to produced water, or are they necessary for implementation of our other existing permits?
They are relevant to our existing permits.
Thank you. And they are important for the implementation of those existing permits. Is that also true?
Absolutely true.
Okay. Mr. Herman, returning to you, there was discussion regarding this, perhaps talking about some of the similarities between reuse of municipal wastewater and produced water. Are those two really comparable, or and why or why not?
I believe that there's important distinctions to be made between the two types of uh, influent or type of wastewaters. In a municipality, it's not perfect, but they do have some control over what goes into their sewer shed. They can have a pretreatment program, or they can have city and county ordinances that restrict um, sales of certain materials. And with produced water, that is not necessarily the case.
Thank you. Let's see. Ms. Lucas Kamat, once again. Mr. Hightower talked about a presentation that was given by the consortium. Do you recall that testimony?
Yes, I do.
What was the subject of that presentation?
So it was part at the annual meeting of the Produced Water Research Consortium. There were multiple presentations on analytical results, and it was part of that analytical studies.
And did you attend that presentation?
Dr. Hu and I both attended that conference, yes.
Was the information in that presentation ever submitted to the department?
No,
Was it available on the consortium's website, to your knowledge?
I have not found it on the consortium's website.
Is displaying data during a presentation the same as submitting that data to the department, in your opinion?
No, it is not.
These, one more, these rules are being proposed pursuant to the Water Quality Act. Is that correct?
Correct.
And to your knowledge and in your experience with the Water Quality Act, does that act give the either the department or the commission any authority to regulate workplace safety?
No, workplace safety is not in the Water Quality Act.
Does and again, to your knowledge, does the department also have a OSHA bureau?
Yes, the department has an OSHA bureau.
Does the state of New Mexico have OSHA rules that regulate workplace safety?
Yes, the Environmental Improvement Board promulgates OSHA rules.
And again, in your experience in your other positions with the department, do you know if those rules cover worker exposures to toxic and hazardous materials, for instance?
To the best of my knowledge, they do.
Do those rules apply to workers in the oil and gas industry?
Yes, they do.
Would those rules also apply to anyone working in say, a produced water demonstration project?
Yes, they would.
Does the department also have a radiation control bureau?
Yes, they do.
And has the Environmental Improvement Board promulgated rules regarding exposure to radiation, to your knowledge?
Yes, they have.
And maybe this is for either you or Mr. Herman or both of you. In your experience working with ground or surface water, when the department is inspecting a facility and the inspector becomes aware of possible workplace hazards, what typically do our folks do in that situation?
So I'll address this first for surface water and then let Mr. Herman address it for groundwater. In the surface water Bureau, our inspectors inspect under EPA.
Ms.
credentials.
Kamat, it's hard to hear you.
Oh, sorry. I will address this first for surface water quality, and then I will pass it to Mr. Herman to address for groundwater. In the Surface Water Quality Bureau, when we inspect a facility, we are credentialed under EPA credentials. When we go into a facility, when we see hazardous or unsafe situations, we do, the inspectors will point it out to the staff that they're with, and then we will have a discussion. And sometimes it can be as simple as you don't have chalk blocks on your truck. Let's put those on. Sometimes it can be more complex where we're not safety experts. So we'll provide the information to talk to the OSHA Bureau. OSHA does have a compliance assistance program, and I may not be using the correct term there, but we have their information and can refer them to that group. And then we will also contact our OSHA contacts we have internally and say, hey, we observed these things, these items.
And Mr. Herman?
Yes, the Groundwater Quality Bureau consistently does inspections, and if we determine there's a lockout tagout issue or an enclosed space issue, we will refer. We'll speak to the operators of the facility as well first, but we will ensure that the referral occurs over to the OSHA Bureau. Very recently, last year, a facility was remediating soil and had excavated greater than 6 feet below the surface, and the operator was not concerned about it, and we referred that immediately.
I'm sorry, could you say that last part again? The operator
Was not concerned about the violation or the unsafe working environment that they were creating, and so we immediately referred that to the OSHA Bureau.
And Ms. Lucas Kamat, when you were talking about OSHA rules that pertain to exposures to toxic or hazardous materials, do you know from your experience whether those rules also include mandates for the use of personal protective equipment when appropriate?
I know that PPE is covered in personal protective equipment is covered in implementation. I don't know if it's explicit in the rules, but
Okay.
it's common best management practice that to protect your employees, you provide them the appropriate equipment.
Thank you. Okay, back to Mr. Herman. There has been what I will describe as some deliberate misinterpretation of some of your testimony, and I'd like to just kind of drill down on so we can talk more precisely about some of these. During your cross-examination, you described the need for a discharge permit for a hypothetical storage unit with lined impoundment. Given that there is a risk of discharge, is it the position of the department that any and all storage units with a lined impoundment or other secondary containment would automatically require a discharge permit from the Groundwater Bureau because of the risk of discharge?
No, that is not the position of the department. Historically,
Go ahead.
the department has required discharge permits on operations utilizing a lagoon or secondary containment because of the risk of release. But the use of a lined lagoon or secondary containment is not the trigger for a discharge permit requirement. There is no regulation that requires a discharge permit for a lined impoundment or secondary containment, to my knowledge. There may be a scenario where appropriate technology and safeguards assure there would be no discharge. A project utilizing impoundment with secondary containment could receive a no discharge permit required letter upon submittal of the NOI. This is true of any kind of proposed project that is determined to be conducted in a manner that doesn't have the potential to cause any kind of release to move directly or indirectly into ground or surface water. The project would receive a no discharge permit required letter.
So, Mr. Herman, during cross-examination, you answered many questions about the proposed produced water NOI regulations, and there seems to be some confusion about how exactly the department will process the produced water notices of intent that will get submitted. Can you just walk us through each step the department will take to process a produced water NOI?
Sure. The department would review the NOI to determine if the proposed process, technologies, or methods are as protective or more protective of ground and surface water when compared to the methods that are being used elsewhere. Make a determination that the proposed project will be conducted in a manner so that there is no potential for produced water or treated produced water to move directly or indirectly into ground or surface waters. For any project, if the proposed project is determined to be conducted in a manner that doesn't have the potential to cause any kind of produced water or treated produced water to move directly or indirectly into ground or surface water, the technical staffer will draft a no discharge permit required letter.
Okay, you mentioned proposals or processes that have not previously been evaluated by the department. If a company submits a produced water NOI to the department that includes a component, process, or method, including for storage of produced water or treated produced water, that the department has not previously reviewed or evaluated, how would the department handle that?
The department will review produced water notices of intent on a case by case basis and in the context of the site specific parameters, including any components, processes, technologies, or methods that the department has not previously evaluated. The department would determine if the proposed processes, technologies, or methods are as protective or more protective of ground and surface water when compared to the methods that are being used elsewhere.
Okay, returning to an earlier line of questioning regarding the department's timeline to consider uh, discharge standards. Does the department have a prescribed timeline for this?
No, NMED will follow the science and availability of the data. The department will bring proposed rules to the WQCC when the science, technology, and data are ready. As we evaluate existing science and as projects move forward, allowing the department to gather more data, the department will propose additional rules specific to reproduced water or reuse as the science supports it. Additional reuse rulemaking is proposed to start this year and continue on an ongoing basis.
Thank you. That's all the questions I have.
All right, thank you. Is there any reason not to excuse, excuse the department panel at this time? Any reason?
Your
not
Honor,
to
this is Mr.
excuse?
Maxwell.
Yes, Mr. Maxwell.
I have one cross-examination question for Ms. Fulham on redirect.
Recross, yes. Go ahead.
Ms. Fulham, in your expertise, is it reasonable to expect members of the public who did not hearing notice via email or mail and were unaware of it due to its absence from the expected WQCC website posting location? Again, is it reasonable to expect members of the public to provide feedback on its adequacy or visibility?
Thank you for the question, Mr. Maxwell.
So, Mr. Maxwell, I think her testimony was that no one had given her the feedback that they did not have notice of the rulemaking and the hearing. So I'm just going to very quickly shorten your question, but I'm gonna do my best to ask it. You said you didn't get any feedback like that. No one reported to you that they didn't have actual notice.
Correct.
Is it reasonable to think that um, just because you didn't get that feedback, uh, perhaps uh, someone didn't see it, and so they didn't give you the feedback?
I believe that's a reasonable question. However, not only have the department put the information out there for the hearing notice in multitude of places and to over 3,000 individuals, 135 stakeholders, all the tribes. It also has been in the paper. There have been protests outside notifying people. It has been on social media by other entities. So I actually find that it would be unreasonable if someone had an interest in reuse, produced water, the environment, or water protection in New Mexico in general, that they would not have had some level of notification.
All right. Thank you. And thank you, Mr. Maxwell. Is there any reason not to excuse the department panel at this time? Terrific. Thank you very much for all of your testimony. We will turn now to Mr. Hightower. I've been seeing Mr. Hightower there on the platform. We're going to complete his cross-examination. My note as to where we left off is now buried in this stack of papers. Had we finished with Mr. Davis's cross-exam and we were moving to Mr. Dodd? Is that where we were? Oh, Mr. Wexler. Yes, that's right. We need to loop back to you. Let's loop back to you first. Yeah, I'm just about to explore that. Mr. Hightower, can you hear me? He may have stepped away. Mr. Hightower?
Yes, I can hear you.
Oh, terrific. Uh,
Would you like for me to start my video?
yes, please.
Okay. All right, thank you.
Oh, thank you so much, Mr. Hightower. You'll remember that Mr. Wexler was had a conflict and unable to ask you his questions when we began your cross-examination on behalf of NMOGA. So we're looping back to him before we go to the other parties who presumably might also have cross-exam. Mr. Wexler.
Thank you, Your Honor. Mr. Hightower, can you hear me?
I can hear you just fine. Thank you.
That's great. I appreciate your patience. Thank you for your willingness to, over multiple days, be available.
Well,
And
you made accommodations for me, so I appreciate that.
did you receive, I sent an email to all of the parties with the exhibits that I might ask you about. I just want to see if you were able to ultimately receive those.
That was a share file, and I was not able to download the share file with the remote internet that I have right here, so I don't have it.
Okay, and then, yeah, you informed me of that, and I sent you a separate set of emails, one each, with the exhibits.
Well, I've been listening to the hearing. I haven't had a chance to open my email.
Okay.
So,
well, let's see how it goes and see if you're able
but
to.
if there are exhibits from presentations that I've given or comments that I've made, I'm sure that I can remember them and talk about them. I'm not worried about that.
Fair enough. Some of them are. Do you have
Okay.
before you your notice of intent?
My testimony, what I prepared, yes, I do.
That's great. If you could look at exhibit 1 to that, which is page 5.
I have page 5. Yes,
And that was submitted to the Water Quality Control Commission, is that right?
that is correct.
On April 15th, 2024, I believe.
Yes,
It indicates, it actually has the current docket and hearing. Is that right?
yes, it does.
Did you prepare this exhibit for the purposes of this hearing?
Yes, I did.
The authors are indicated as you, Dr. Pei Zhu, Dr. Yanyan Zhang, and Dr. Robert Young. Is that right?
Correct.
The bios of all of those authors are provided.
Correct.
Did Dr. Zhu, Dr. Zhang, and Dr. Young have the opportunity to review and provide input on this document?
Yes, they did.
Did they agree with the contents?
Yes, they did. There was a couple of comments.
Hold
but,
on, hold on, Mr. Hightower. I have an objection from Ms. Nanasi. Ms. Nanasi? Okay. Would you lay a would you lay a foundation, please, Ms. Wexler?
I'd be happy to. Can I also ask for a point of clarification? And that is, are you going to allow other parties to object to the testimony of Mr. Hightower? Because thus far I've been withholding objections because it wasn't my witnesses on the stand.
No, I think if someone has a legitimate objection, they can raise it.
Fair enough. Mr. Hightower, so I understand from your testimony earlier that you actually circulated this paper to Dr. Zhu, Dr. Zhang, Dr. Young. Is that right?
Correct.
And did they tell you after that review that they agreed with the contents?
After I made the corrections and changes they recommended, yes, they did.
And those changes are reflected in Exhibit 1, right?
Yes, they are.
In fact, am I correct that Dr. Zhu actually was at the hearing on Wednesday, maybe? Is that right?
Yes, she did attend. Yes.
Now, let's talk a little bit about your recommendation here. The originally filed rule would have allowed a party to obtain a discharge permit for treated produced water. But on March 20th, the department filed its first amended petition, which if adopted would prohibit discharge permits. So there's been a little confusion about the consortium's position on that prohibition, at least for discharge permits for treated produced water. And as I understood your testimony from Wednesday, the consortium was agreeable to a prohibition on discharge permits for raw, meaning untreated produced water. Is that correct?
So,
Ms. Fox, hold on, Mr. Hightower. You may be about to make the same objection I'm going to raise, which is I know that there was some questioning by at least one commissioner in which the lines between Mr. Hightower testifying on his own behalf and Mr. Hightower testifying on behalf of the consortium were blurred. But I really have to insist that counsel honor that distinction. He's here giving testimony on his own behalf, not speaking for the consortium.
And yet he has knowledge of what the consortium's position was. And my understanding of his testimony on Wednesday had to do with the understanding of the consortium. And so I'm certainly allowed to inquire into that testimony, which occurred on Wednesday.
Okay, in that case, we're going to need to know where the consortium took that position and whether then that is in the evidentiary record, Ms. Fox? No one can hear you unless you're at a microphone.
Madam Hearing Officer, members of the commission, I think some kind of foundation needs to be laid if Mr. Hightower is going to purport to speak on behalf of the consortium members, which consist of nonprofits, industry membership, other types of associations, the extent to which the consortium was consulted on his representations about what the consortium's view is. How's that consultation take place? Is there a vote? Where in the organization documents does Mr. Hightower have this authority? I haven't seen it, for example, in the operating plan, which I understand is, the basic operating document. So, and he has already represented, he is here to speak on his own behalf. And I think to not prolong this issue anymore, I think his questions should be limited to him speaking on his own behalf. Because I do not believe he has the authority to speak on behalf of the
And again,
consortium.
I'm not asking him to give testimony on behalf of the consortium here, other than factual testimony. He is the director of the consortium. He certainly is in a position to understand what the positions of the consortium were on things that factually happened.
And I understand the distinction you're making, Mr. Wexler, and I don't think you're wrong if you can lay a sufficient foundation. Not just ask him what's the consortium's position, but has the consortium taken a position? Where have they taken it?
They may not have been in writing, but I'll certainly see what we can learn.
You need to go a long way that way. Ms. Fox?
I have no more.
Okay, Mr. Knight?
Yeah, I guess I would object to even the use of the term, the consortium by definition is an affiliation of different groups and different people. And to say that, the consortium has this position or that position, that may be the position of individual parts of the consortium, but without any evidence or foundation that the consortium as a whole has either taken a vote or documented in some other way or in some public forum a particular position. I don't think any testimony regarding what the consortium as a whole, what position the consortium as a whole has is relevant without such a foundation.
All right, and that's the sort of foundation I'm talking about.
Yeah,
Mr.
I understand,
Wexler.
except that oftentimes entities, consortiums, boards, things like that aren't taking official votes on things. It doesn't mean that they haven't discussed it within the context of the leadership. And so let's see what we can understand.
Right, and at some point we're going to get to hearsay, but
Which of course doesn't apply here because the rules of civil procedure and the rules of evidence of which hearsay is a part are expressly excluded from the rules of the commission.
and yet at the same time, I have to make sure the commission has some reliable information.
I don't think that's what the
to-
rules say. I think the rules say relevant is the one thing
Or-
that's the one rule.
Okay, so you can go a little ways, but I'm going to have to hear a fair amount of foundation before we're going to go to Mr. Hightower speaking about the consortium's position. Go ahead.
Mr. Hightower, were the proposed rules, the draft rules that the Environment Department originally put out, were those shared with you and the other leadership of the consortium?
Yes, they were. There were, through the public comment period, we had a chance to look at the drafts. Matter of fact, a member of the consortium management team was on the produced water action committee, PWAC, and was aware of the original discussions associated with the initial draft that came out. So we as a consortium had opportunity to talk about the draft. And I'm talking for the consortium now. This is procedurally, we did have opportunity. We were asked to work on the draft, and the consortium had membership that did look at the draft, and we're aware that the draft legislation was coming out. Or excuse me.
And were you
mixed that
involved?
up.
Were you involved? Were you involved in that process?
So I was not, but members of the management team for the consortium were. So we did have, and we did get notice from when this was went out for public comment, and the consortium as kind of a management team, leadership team, did make comments. I presented that to consortium members and suggested that they themselves provide comments to NMED. And I think that there were probably several comments based upon what I've heard from consortium members that had provided comments to NMED on the draft rule. Then we did get a copy. When I say we, the consortium had access, and I sent that out to members of the consortium. We looked at it as a management team. From that perspective, the management team thought that this was a good rule. That's all. As far as my discussions today, I do want to mention, and I personally agree with Madam Chair, that I said that I would talk about my opinions, and I am going to only really talk about my opinions based upon the evaluations that I did as in my own perspective. And the reason for that is the reason I have to do that, in my opinion, is when the changes came out at the end of March, we only had 2 weeks to prepare any comments at all on that final proposed regulations. It would have been very, very difficult for the consortium to try and call a meeting in that short a period of time, take a survey, ask for opinions. So what I tried to do was look at it from my perspective of the charter of our consortium, which is to support the evaluation, scientific evaluation and science associated with the fit for purpose treatment and reuse of produced water. That's our charter. And so when you put a rule in, when the rule changed, in my opinion, this is again my opinion, to prohibiting the fit for purpose treatment and reuse of produced water, it seemed like it was going in a direction different than our charter. So I prepared some information based upon my review that this was probably had changed in a direction that was inconsistent with what our charter was. I provided that information to the management team of the consortium, which are the 3 people that we talked about, additional 3 people. They made comments and I submitted it as I'm not representing the consortium. I'm representing my views of how this legislation fits into the consortium's guidelines. We did not take a poll, and so I cannot represent the consortium. Our charter talks about using the approaches that are done by the National Academy of Sciences. So if the consortium comes out with a edict, it has to have at least 80%, a supermajority of people that agree. I did not have time in that short period of time to get everybody in the consortium together and vote on a stance. So this is my testimony, and I think we ought to keep it in my understanding as a person who's been trying to coordinate these activities around collecting the right science and doing the research to be able to support fit for purpose treatment and reuse. And so if you can keep your questions in that format and ask me my opinion, I think that it's going to be good for everybody, and we won't have this issue of my ideas and suggestions, and the suggestions of the management team within the consortium their suggestions to me on how we should respond. So hopefully I'll set that to bed and then we can move forward. And I will give you my opinions and as my testimony before. I can provide information on my past experience in desal, my past experience in working with produced water, my current experience in working with the consortium. But so let's just stay there, Jeff, if that's all right with you. I think
Yeah,
we can
I'm
do
happy
that.
to. I'm happy to do that. I respect that. Let me just ask you one clarifying question on what you just said, and that is, you said the consortium did support the rules. Do I understand when you're saying that you mean the rules as they were submitted on December 27th, 2023?
That is correct. And I think I've stated more than once that I think from the membership that we have and the comments that I've gotten, that was a well-written, well-documented, a great approach that evidently had taken input from, as NMED mentioned, some 400 pages or 400 applicants, or excuse me, respondents. And I thought that the rule that the regulations that they had were very consistent with what the consortium wanted to, was the charter. It was consistent with the APA's water reuse action plan, had the need for notices of intent, needs for coordinating with NMED to do demonstration projects. I think that all of those were very much in line with the way our consortium has been organized to try and develop that science through testing and evaluation that's coordinated through NMED, that's watched very closely, that tries to expand the information on what treated produced water will look like, how it has to be treated, what we can do to make it safe. So I think from that standpoint, that first original proposal that came out in December into December was right in line with where we have been working for the last 4 years.
And at the time, did the consortium have an understanding that discharge permits would be allowed for treated produced water?
Hold on. Your objection,
So-
Ms. Fox? Hold on, Mr. Hightower.
Okay, just a minute.
I think we need foundation laid for how the consortium made this decision.
He just
Was-
talked about
What was there a meeting? Was there a vote? Who was in the meeting? What was the vote? Did they get this 80% that he claims is necessary? Where is it in their organizational documents that gives him the authority to speak on the consortium's behalf on this particular issue? I don't think all that foundation has been laid.
He just
Okay,
talked-
hold on, Mr. Wexler. I need to ask you to stop talking over me
Understood.
and the other council and Mr. Hightower. You need to lay a foundation for these questions.
Except that he just provided that foundation. He indicated that he shared the draft with a number of parties, that they all looked it over, they talked about it, they reached a consensus, they provided a position, and all of that was supportive of the existing rules. That is sufficient foundation, even in court, for that. And again, the commission's rules on rulemaking do not adopt and expressly disavow the rules of evidence. And I think foundation is a rule of evidence. It's rule 11-104. So
Okay. I believe that laying foundation for questions on matters of importance, particularly when this information was not specifically included, for example, in the technical NOI, and in fact was implicitly or explicitly excluded by Mr. Hightower's statement that he was speaking on his own behalf. And yet, so to the extent you are straying from that to get a consortium position, we do have to be careful. We do have to take extra steps. We do have to lay a foundation for that.
And so is the reason you're sustaining the objection is because of foundation within the rules of evidence?
Foundation, yes, I want you to lay a foundation.
Thank you. That's helpful. Mr. Hightower, on your in your testimony at page 3, you indicate your recommendation to the commission here, and you say it's in the best interest of New Mexico to reject revised proposed new rule 20.6.8. You see that?
Page 3.
Yes, sir. It's 1, 2. It's below the bullet points.
So my page 3 has the ends in bullet points, and then it goes over on page 4, still has some more bullet points.
Do you
And
have?
they're supporting technical data and information.
Yeah, I think that might be your exhibit 1.
That's
And
my exhibit 1. Yes, exhibit 1 is what I thought you asked me to look at.
Oh yeah, I apologize if I wasn't clear. So I'm asking about the notice of intent, which was the document to which exhibit 1 was attached. Do you have
Okay.
that in front of you?
I just have exhibit 1. I don't have the other one.
I'll read it to you. You say,
Okay.
quote, it is in the best interests of New Mexico to reject revised proposed new rule 20.6.8 and either accept the original proposed new rule 20.6.8 or simply require that all non-traditional waters, including produced water, be treated to meet the unidentified numerical and associated narrative discharge standards noted in NMAC 20.6.4.900 for the application required and add a requirement for wet testing of the treated water. Is that your
Objection, that is not what this says. There was a mistake in the reading.
Mr. Wexler, do you?
I don't know what the mistake was.
Okay,
Yeah,
Ms.
I mean-
Nanasi, would you help us out?
Yes. Water be unidentified numerical. Words here say be treated to meet the identified numerical.
Okay, Mr. Wexler?
Yeah, any error was purely unintentional.
All right.
My question, Mr. Hightower, with the amendment, which I accept, is that your recommendation to the commission?
Yes, that's my recommendation.
Understood, yes. All right, I have a couple questions about the New Mexico produced water data portal, just to follow up on some of the questions that were asked of you.
Well, just a second, Mr.
Please.
Wexler. You also asked me about the concept of a notice of intent. And I want to mention that we currently do follow a notice of intent. The consortium has been following a notice of intent with NMED for the last 4 years. We follow a notice of intent approach, whether it's going to be exactly as they propose moving forward, but we have a notice of intent, and the consortium has been following that. The consortium agreed to that, not me, but that is part of our rules to do demonstration projects currently. We have to identify those. We run that through Kathleen and her team at NMED. They get the notice of intent from NMED. So far, from all the people that have done testing, they have had no problems with the notice of intent. We've never had anyone back away from that. They've told me that NMED has been very fair and straightforward in moving forward with the notice of intent. So notices of intent are something that the consortium has agreed to and we move forward with. And I think that that's imperative that those kinds of notifications are given before you do any of these treatment processes. So there is no discussion on our part or my part on the notice of intent process. It's a fantastic process. I will tell you, we have gone one step further, and NMED has requested, based upon some discussions we had, that we also have to contact people that are not, that we will also be working with. If it's BLM land, we also have to go and get a notice of approval from the BLM. If it's on state land, we get state land approval. And if it's on an OCD site, OCD managed site, we go and get OCD approval for that. So the projects that we have that are on BLM land at an OCD site and coordinated through the New Mexico Environment Department also have approvals to operate from BLM and OCD. So I think that from that perspective, you don't see any push. You would not see any pushback from consortium. I can't speak for the consortium, but I don't think you'd see any pushback from the consortium members that the notices of intent and requirements to work through NMED would be a problem, because we're already doing that today on all the activities that we have that are field activities. So hopefully that answers that question before we go on to the next. Fair enough?
Thank you. Turning to the New Mexico Produced Water Data Portal, do you have access to the exhibits yet?
No, I don't, but
That's fine.
I
let me just
know the portal. I've used the portal. I can answer questions about the portal. Go ahead.
understood. I actually only have one question. I mean, I'll first point out that you all have a fact sheet on the portal. That's NMOGA Exhibit 36. But my question to you is, Commissioner Zemlich had asked questions about the lack of data in the portal. And my question is, when does the consortium anticipate that this portal will be more populated?
So the biggest issue with the portal is that, first of all, we worked with the Groundwater Protection Council to put that together in support of the US EPA, who asked us to, at the beginning of the consortium, could we come up with a way to have a national database on produced water so that all states kind of work similarly. EPA suggested the Groundwater Protection Council because they do the underground injection control. They manage frac focus. They have access to all of the produced water and fracking data. They have a Water Star program that has been funded by the EPA as a national portal. So rather than develop a new portal with the limited amount of funding that we had, we agreed with EPA to go with the Data Star. We worked with the Groundwater Protection Council. The big requirement for that was to try and collect data from around the country. The way that the EPA was working with the data portal activities and the Water Star program was to collect data from around the country to put that into a national database. So we were kind of the first step in putting together a statewide database on produced water. The problem has always been is that collecting that produced water data is very difficult unless you can get the operators and the producers and midstreams to work with you, because what we're putting in the data portal is quantities of produced water available for treatment and reuse. And most people don't go out and sample a few wells here and a few wells there. Most of that sampling is done by the operators, the producers and midstreams. So we've been spending the last year and a half trying to work with operators, midstreams, and producers to collect some of that data. They collect not all of that, a lot of data, all of the constituents, but they collect data on a daily basis from every saltwater disposal well where they inject to try to maintain the integrity of the saltwater disposal well. So we have an activity underway with NMOGA, with the consortium, and with midstream users and producers to try and collect that data. We have been trying to do that for a year and a half, but because of the lack of funding, we put those kind of on the back burner and have a plan, but we can't implement it until we can get enough funding to fund the GWPC to take that data that we have enough funding to go through a QA/QC, independent third party to QA/QC that data, and then put that data on the website. So we finally, for this first time in the history of the consortium, and this first time in 4 or 5 years, that we've got funding from the state of New Mexico to allow us to move forward with putting that data, collecting that data with producers and getting that into the database. We've talked about it for a year and a half. We have a plan, we have a strategy set up. We have a way to do that. We just haven't been able to fund it. Now we have funds to do that. So that's in our plan for this year. So that's the effort to try and see if we can't get out of the 350 or so saltwater disposal wells, get data this year on another 50 to 100, and next year another 50 or 100. And hopefully within the next 2 to 3 years, have data on 95% of the saltwater disposal wells in the state of New Mexico, if we can continue to get the funding so that we can continue to update that. We have a plan, we have a strategy. It's been worked through the consortium and the working groups in the consortium. We just needed the funding to do that. We finally got funding to do that. I've had discussions with Groundwater Protection Council already this year that they're in the process of getting ready to work with us over the course of the next 6 months to get that next set of data. So that's our plan. That's the consortium's plan. That's what we've been working on for the last 2.5 years, and that's the direction we're going.
Switching topics to the characterization of produced water, and on Wednesday you testified that based on the results of all the work that the consortium's been doing, the characteristics of produced water in each of the main basins in New Mexico is actually in a fairly narrow band. Is that correct?
Generally, yes. And so when you're talking about produced water, there's a lot of variability, but we do have enough data on the Permian Basin that says from the 40 or so wells, 46 wells that Dr. Chu looked at, that the numbers for produced water in the Permian Basin, as far as, and I'm going to use TDS as a surrogate for the kind of the difficulty of treatment. But what we're seeing, and I think I presented that. I don't think, no, it was in my presentation that people did not get to see. For the Permian Basin, for the unconventional wells, for the most part, what we were looking at is produced waters in the 100,000 TDS to 130 to 40,000 TDS. That's probably 75% of the wells are in that level. In the San Juan Basin, most of the wells are in the 20,000 to 35,000 part per million TDS. So there's more variability. The Raton Basin is much less than that, but I think from a basin perspective, which is important from a technology selection, is that we understand in the Permian Basin that most of the waters are going to be in the 100,000 TDS range, which means that we're going to have to use thermal technologies. And in the San Juan Basin, we're looking at waters that are on the order of seawater. And there are technologies for seawater, specifically saltwater RO systems. So at least we know the types of systems that we should be looking at for treatment in both the Permian Basin and in the San Juan Basin from a general perspective. So from that standpoint, from a treatment for reuse, it gives us an idea of which technologies we should be looking at and the types of constituents and levels of contamination that we should be considering for both pre-treatment, treatment, and post-treatment in both of those two major basins. Hopefully that answers that question.
It does. If you turn to page 15 of your exhibit 1.
Okay.
And what my question has to do with the second paragraph, and 3 lines up from the top, you're talking about that some reports have suggested that produced water can have over 1,000 chemical constituents. You see that?
On page 15 of Exhibit 1.
115. Let me know when
And
you're there.
where are we talking?
The paragraph that begins the produced and other water testing.
So my page 15 starts with table 4.
Table 4, let me see. So can you go back 4 pages? Maybe it's page 11, PDF page 11. Does that page start with the words figure 3?
Yes, it does.
Second paragraph on that page says the
Okay.
produced and other water testing. And then
Okay.
midway down, you have a sentence that reads, while some reports have suggested that produced water can have over 1,000 chemical constituents. You see that?
Yes, I do. Yes.
You familiar with what's been called in this hearing the Danforth paper?
Yes, I am.
Is that a reference to the Danforth paper?
It's a reference to a couple of, not only the Danforth paper, which mentioned 1,200, but also to the EPA database, I think that has 2,700 constituents. And then it also refers to some studies that were done out of the Mideast, where they looked at basins across the Mideast, and they came up with 4,500 constituents. And so those all sound kind of disparate. And when we compare it with some of the work that Dr. Zhu had done, where we looked at 40 wells specifically in the Permian Basin and came up with a much lower number of constituents. So in my past work, I had looked at those different studies, and what I was able to determine, and this is my determination, my evaluation, was that what we're seeing is the number of constituent kind of varies by basins. And to me, it makes sense that different basins have different geologies. They have different types of hydrocarbons, whether that's oil or gas. And so as I looked at this data in the past, I was not able to present on that. What I found was essentially about 100 constituents per basin, plus or minus 20 or 30 constituents per individual well. And so the basins seem to be the thing that drives the general quality of the water. And then the wells each well has a slightly different set of constituents. So what I think that I have found in the work that I have done is that if we look at, quote, the Permian Basin, we should see maybe 100 constituents of importance, and then there are going to be 20 or so that we're going to have to look for and we may not find. And that is the reason that for the consortium, when we worked in trying to do the water quality evaluation, we didn't look for just 100 constituents because we know we're going to miss a bunch. We looked for almost 400 in our sampling plan. And that sampling plan, we know that as we individually, those wells, there may be some that don't show up in that 400 constituent sampling plan. We're going to have to go in and look to see if there were a few others or some that we missed because of that specific well, that specific set of conditions for that production. That's why we have this concept that Ms. Murphy has mentioned multiple times that the consortium agreed to, that we would do this broad set of analysis, targeted analysis for 400 constituents, and then a non-target analysis to look for things that might be specific in a well. And that's why we, in our risk and toxicology side, we also look at the wet testing to make sure that anything that we never found, couldn't find, that was well below any current detection limit, that we have an idea that there's not going to be something in there that we can't find or is below detection limit that would have impact to risk and toxicology of humans or the environment. And that's the same reason that we take our treated produced water and do human cell line testing. That's state of the art also, but we do that through the laboratories, through our laboratories at New Mexico State to make sure that there's no human impacts. So our requirement is for human and ecological health. So we look at both the human side and the ecological side. Human side through the human cell line testing, ecological side through the wet testing. So that's a summary of what's in that.
Understood. If you turn back one page in your exhibit, which I expect is page 10, PDF page 10,
Yes.
we can see figure 3. Do you see that?
Yes. Figure 3. Yes.
Yeah, and figure 3, which we've seen in papers and in some of your presentations, it shows raw municipal wastewater, raw Pecos River water, and then some of the data from this Zhang 2022 paper, which I understand comes from the year 2020.
That is correct. That was stuff that was the sampling. Almost all of the papers are, by the time they come out in a peer-reviewed journal, which is something that NMED wants, and it fits into some of the other testimony that I've given, is it takes about 2 years to go from getting the raw data to getting it in a manuscript, getting it through for approval, and then getting it published in a peer-reviewed journal. There's a 2-year gap there. So oftentimes these papers are 2 years in the making to get that preliminary data to a data quality that's needed for regulatory concerns and it's needed by NMED. So anyway, yes.
Understood. My question is, you have these 3 raw municipal waste, raw Pecos River water and raw Permian produced water. What's the point of that figure?
The point is that we have been making for a year is almost exactly the same point I think that Chairman Thompson mentioned, is that all of these wastewaters, all of the wastewaters, municipal wastewater, agricultural return flows, which end up impacting the Pecos River, industrial wastewaters, produced water, that's an industrial wastewater from the oil and gas, all have a lot of constituents that need to be looked at, and you need to be careful about treating and reusing those when you're looking at public health and safety. So my personal opinion is some of the things that we're doing within the consortium, as far as human cell line, as far as wet testing, as far as non-targeted analysis, looking at the unknowns, there's not a lot of people that are doing that. And I think as we move forward in this wastewater treatment and reuse for specific applications, that's the kind of work that we're all going to have to do to use all of these wastewaters. So I just want to remind people that the kinds of things that we're doing in the consortium that I think is state of the art or state of the science, and we need to maybe apply some of those to other waters as well to be safe to the public and the ecology.
If you turn to page, we have it marked as 16. I expect it's PDF page 12. And I'm looking at table 1.
Yeah, this is 12 on mine. The top, table 1.
That's correct. I mean, first, can you just describe what's there before I ask my question?
Sure. This is a table that we've put together for the public in the past and put it in public. It tries to let people understand some of the concerns about produced water. And so a couple of things here. I think most people understand TDS is one of the issues that has to be addressed to make this water safe. But there's also things that you want to, chemical oxygen demand, COD, total organic carbon. Those are all total values that kind of give it a sense of how difficult it's going to be to treat the water, or how toxic that water could be if it's not treated. And the other thing that we added in here is NBAS, methylene blue and ionic surfactants, because that's essentially where the PFOSs and the PFOAs come in. And so we're not trying to hide anything from anybody, that these waters are high in these constituents. And so these raw produced waters are rather difficult. Ammonia is very high in the produced waters. The ammonia level has to be below 10 and to be permitted to be discharged to the environment. So we have to reduce those numbers by a factor of 100 if we want to treat that correctly. TOCs are in the hundreds. They have to be below 3 parts per million in milligrams per liter. So we have to remove that by a factor of 100 also. MBAS, it is showing up. A lot of companies in the past have used municipal wastewater for fracking, or what I'll call fresh water out of the Pecos River, even though we don't do that in New Mexico. But that has PFOS in it, and so that goes into your produced water. We're going to have to look at that. You can see that the number that we had 0.047 on MBAS, for example, was it was below the previous standard. It's above the current standard that just was implemented. So there are a lot of constituents in produced water that we have to take out. The concept here was to let people understand that these are kind of drive the technology and the technology selection and the treatment, post-treatment, pre-treatment, to try and make sure that there's a lot of constituents that we need to get out of this raw water to make it fit for purpose for public or environmental consumption. So, okay, that's what that was to show.
Yeah, and that's at the end there, you got exactly to my question, and that is the consortium is able to use the data that you've collected to design the treatment for fit for purpose. Is that right?
Yes, that's the purpose for collecting the raw produced water, is to see exactly where we ought to focus our post-treatment, pre-treatment, et cetera.
Let's talk a little bit about the so-called unknown unknowns, and you've described some of the work that the consortium's doing. On Wednesday, there was discussion of a paper that the consortium had recently published, and we put that in the Dropbox and all those things as a NMOGA Exhibit 139. Unfortunately, you don't have it before you,
No.
Mr. Hightower, but let me just read it to you and see if this sounds like the paper that you were referring to. I think that both Commissioners Patton and
that's based upon that is the final report that we did for the data that was presented in December at our annual meeting.
Understood. Yeah.
That's the data that was going into the journal article that has now been peer reviewed, and it's now available for public use because it was, has gone through all the hoops associated with peer review. And that just came out just like in the last couple of weeks.
Yeah. What I want to get you to do,
Okay.
Mr. Hightower, is to identify this, and I'm going to read you the title and get you to confirm it. This is something that Commissioners Brankert and Patton had asked about. So what's been labeled as NMOGA Exhibit 139 has the title Non-Targeted Analysis and Toxicity Prediction for Evaluation of Photocatalytic Membrane Distillation Removing Organic Contaminants from Hypersaline Oil and Gas Field Produced Water. It's published in the Journal of Hazardous Material in 2024. Does that sound like the
And the authors are Dr. Hamali and Dr. Young and Dr. Shu?
Among others.
Yes, that's the paper I'm talking about. Mm-hmm.
Actually, I don't see Dr. Molly.
Himali
Oh,
Delinquent.
Himali, I misunderstood you. Thank you.
Okay.
Yeah. And so actually, Madam Hearing Officer, I move the admission of Namoga Exhibit 139.
Objections? No? All right, it's admitted.
Thank you. So I'm not going to ask you questions about that, Mr. Hightower. The commission can read it and reach its own conclusions on that. What I am going to ask to sort of figure out to close out this idea of unknown unknowns is on Wednesday you said that the unknown constituents in New Mexico are not unknown anymore. What did you mean by that?
Well, maybe I might have stated it a little bit too directly. What I meant to say is that we now have a process. We have a forensic lab set up at New Mexico State using state-of-the-art equipment that we believe that we can now take treated produced water, look at it to see what's left over in the treated water, and see what kind of constituents were below the current detection limits for the standard GC mass spec systems. So a lot of people use GC mass spec, gas chromatography. Just say GC mass spec. What we're doing is taking that treated water that would be the low detection limits of the GC mass spec, running it through a high resolution LC mass spec. And what that does is, even though it lowers the detection limit to parts per quadrillion, and so we're able to pick up things that were currently unknown to us. We thought that we had cleaned it all up. We can now look at that water and say, no, there's still 2 or 3 things, or 5 things, 10 things, 20 things left in it that we need to continue to possibly remove. And so what we do is we compare that information to current database of toxicity of chemicals to figure out, is there anything left in that treated water that needs to be treated again? If we do, we can design a post-treatment system, a polishing system to go out and take those specific constituents out. And that's what Dr. Molly's paper talks about, is how do we, one, find those, and then how do we remove those? What kind of processes we need to follow to get those down to levels that then are protective of human health. And we use the human cell line testing and the wet testing to show, how we can get to 100% survivability of that treated produced water, and then how we can get to no impact on human cell lines. So what I meant was, we now have a process, I think, in place where we can identify the unknowns and detect their impact, and approaches for polishing that will make that water non-hazardous for humans and the environment. That's what I meant.
Understood. And I'm going to just, I know it's not before you, but I'm going to refer you to one of your fact sheets. This is NMOGA Exhibit 35, called Fit for Purpose Use of Produced Water. And at the bottom here, you address some of the issues you were just talking to, and it talks about a multi-pronged chemical, toxicological, and human health and safety testing strategy, providing overlapping analysis and evaluation of the human and environmental health impacts. And so you've talked about several of those, the wet talk testing, the human cell line testing. I want to ask you about the other two that I didn't hear you talk about, and that is number 5 is what you have listed as plant and soil bioaccumulation and toxicity testing in greenhouses at NMSU. Will you just talk a little bit about that and how it fits into the figuring out those unknown unknowns?
Sure. So I think.
Hold on, Ms. Nanasi, none of us can hear you unless you're at a microphone.
Madam Hearing Examiner, I object, Madam Hearing Officer, I object. Foundation, also, this is extremely leading questions, about a fact sheet. We have no idea about that. And I don't believe that there's been any foundation um, for this.
So I believe the fact sheet, I think Mr. Wexler said it was Nemoga Exhibit 35.
Yeah, I understand that sorry about that. I understand that Nemoga put this into evidence, but we don't have any tie between the fact sheet and the witness.
That's okay. I understand your point now. Mr. Wexler, would you address that?
Mr. Hightower, are you aware of the fact sheets on the consortium website?
Yes, I am.
Are you aware of the contents within those fact sheets?
In general, yes.
Are you
because
aware of the,
we have 17 fact sheets, but yes.
are you familiar with the method involving plant and soil bioaccumulation and toxicity testing in greenhouse houses at NMSU? Are you familiar with that?
Yes, I am.
Will you please describe that?
So when you're looking at water quality, and this is through the EPA's RAP program, Water Reuse Action Plan, they continually talk about fit for purpose treatment and reuse, which means that they're trying to they suggest nationally that we tie the treatment required to the application. So one of the applications that they highlight is agriculture. And one of the things highlighted in the Produced Water Act is agriculture. But we know in agriculture that plants have a tendency to bioaccumulate certain toxins. That's one of the reasons that boron is a problem in agriculture, is that the plants bioaccumulate boron and then it impacts the plants. That's an example. So to do fit for purpose applications, we have on our website fact sheets of what we're looking at for surface water discharge, for ag applications, for rangeland applications, etc. So one of the things that we have to look at is this treated water, even though it's below a regulatory limit, even though we've identified that there's nothing that's toxic to humans and aquatic species, etc. Are certain plants going to bioaccumulate these very low concentrations, and then over the course of a year, 2 years, or 3 years, now you have a toxic in a plant that may become toxic to wildlife or toxic to humans. So we have been working with the New Mexico Environment Department with a no discharge agreement, that we can take treated produced water and put it in greenhouses and look at the efficacy of using that for plants. Because there's no discharge, those are protected greenhouses. That soil then is disposed of as in the way that New Mexico State requires for potential hazardous materials to be disposed of, that we can begin to evaluate additional toxicity that might occur through bioaccumulation. And so we have worked with NMED to do that. New Mexico State has done these kind of greenhouse tests for tens of years, maybe even 100 years. But that's the direction that we think needs to be approached as you look at using these non-traditional waters like municipal wastewater, produced water, industrial wastewater, to make sure that there is no bioaccumulation for certain types of species. And it may be, as we look at this down the road, that there may be plants that are not appropriate to use treated produced water on, or other types of wastewaters on. So it's to try and get to that point that we have an obligation to be protective of human and environmental health. So that's why we're doing these kinds of studies. Okay,
Mr. Wexler, it's time for our lunch break.
Understood.
Okay, so Mr. Hightower will resume your cross-examination after our lunch break and after the 1 p.m. public comment session. And I want to invite all of the parties to return after lunch with an understanding of what your calendar looks like over the next, say, 60 days. Because I think it's pretty clear we're not going to be able to make our way through all the rest of the witnesses before 5:30 today. So we'll have that discussion after the public comment session. Thank you.